Hello, everyone. This is Laura with the Chamber. Welcome to today's session on the legalization of marijuana and what you as employers need to know about this. This is a very important topic and very timely. And we are fortunate to have back to the Chamber to work with us Jennifer Shoemaker from Underberg Hessler. Whenever we have a labor HR relevant topic, she is our go-to. So when we reached out, she responded right away to say, yes, we're in, we'll get this put together for you. And so on such a new topic, I'm sure that there are going to be a lot of questions that people have, a lot of uncertainties. So just to kind of give you a lay of the land for the presentation, we are recording today's session, so we will be able to provide you with this after the session. It will also be posted on the Chamber's website as well. Along the right-hand side of your screen, you should see a chat and Q&A feature. Feel free as we go through the session, if you have any questions or anything, you can pop those in the Q&A or the chat feature, and we will address them as we go through the session. And then when we come out of the formal presentation portion, Jennifer will be in the main lobby area, and you'll have a chance to chat with her individually if you have some questions while seated around a table. So I'm going to turn my cam and microphone off as I turn the program over to Jennifer.
Okay, I hope everybody can hear me because it's a little disconcerting not to see faces looking back at me, but it's good to see everybody. I assume that if you don't hear me, I'm going to hear from Laura very shortly. So it's been so long since I have had the opportunity to speak in front of the Livingston County Chamber of Commerce. So thank you for inviting me, and I hope to reconnect with a bunch of you following today's program. And as Laura said, please feel free to write some questions in the chat. If I happen to see them as we're going, I will answer them. And if not, then I will certainly get to them at the end of the presentation. So today our topic is legalization of marijuana and what employers need to know. And so, it's a very interesting topic, of course. This was something that was talked about for a long time in New York, and we thought it was going to happen, and then it didn't, and we thought it was going to happen, and it didn't. And so it was kind of a surprise that it did happen when it did. It felt like out of nowhere, even though we had been discussing it for years. It certainly wasn't the topic of conversation at the time that the law was passed, and there are much speculation on why, the timing was what it was. But in any event, on March 31st of 2021, the Marijuana Regulation and Taxation Act was passed into law. So I am going to share my screen. I have a PowerPoint presentation for you all to follow along. So let's see if I can get that to work. And so you'll note from the title slide that I spell it marijuana with a J. The legislature did a little, hang on a second here. I want to make sure I can, here we go. The legislature used the old-fashioned spelling, which is with an H, which I don't think many of us are used to seeing that, but I kept it this way in the slide because that's the way that the law reads, and that's the title of it. So Marijuana Regulation and Taxation Act. So it was signed into law on March 31st and immediately went into effect. A lot of times when legislation is passed, there's a waiting period and there's time for us all to get our ducks in a row, but not this time. It became immediately effective on March 31st. And the content of the law states that adults aged 21 and over can lawfully possess, use, and transfer meaning give, not sell, up to 3 ounces of cannabis and up to 24 grams of concentrated cannabis. Adults in New York can also cultivate up to 3 mature plants and 3 immature cannabis plants. And I should have written the number 3 in there twice, but it's 3 of each. Another piece of the law, which is important to us as employers, is that records are automatically expunged for people who have been convicted of marijuana-related offenses that are no longer criminalized. So if somebody got arrested for growing 2 marijuana plants and they were convicted, 10 years ago, that is now going to come off of their record as if it never happened at all. And, we're going to talk about drug testing, both pre-employment and during employment. But, one thing that you all are very likely aware of is, criminal record background checks upon employment. And, you have to be very careful when you do a pre-employment criminal background check, because a lot of times, you'll discover that a potential employee has a conviction. And, it's in our nature, I think, to automatically react and say, oh, well, you've been convicted of crime or of a, whatever, misdemeanor, and I'm not going to hire this person. But it's, important as employers that we relate whatever the conviction is to the job duties. And if they don't relate, then you can't refuse to hire somebody based on a conviction. So that's sort of an aside, and something that we all as employers should be aware of, that, if I am convicted of, DWI, and my job duties do not include driving, then you can't refuse to hire me based on the fact that I was convicted of DWI. So, and that's, I guess, a whole topic for another day. But if one of those pre-employment background checks does come up positive for a marijuana conviction, you can't use any longer, that can't be a reason for you not to hire somebody. Number one, even if it is closely related to job duties, for example, if they're operating heavy machinery or things like that, as long as they have less than the required amount in the statute, which is less than 3 plants and less than 3 ounces, then you can no longer use that as a means for not hiring somebody pursuant to a background check. So you want to be real careful about that. And if you ever have a question about that, just give us a call. We're happy to walk through it with you really quickly. Another piece of the law is that cities and other localities can opt out of allowing dispensaries, but they can't opt out of allowing adults recreationally to use marijuana. So that's another, I think, misconception in the press, was that, towns and, cities can opt out. Well, they can opt out of selling it or allowing businesses to sell it, but they can't opt out of allowing individuals to use it. So, whatever town you live in or whatever town you work in, that's something, again, to keep in mind. Records, we already did that slide. So next I want to talk about New York Labor Law 201D. And again, as employers, we should know, and you will know now, that we cannot discriminate against somebody for what they do on their own time that's legal, okay? So for example, if somebody smokes cigarettes and we don't like cigarette smoking, and we have a rule at work that we can't smoke, you can't refuse to hire somebody or discriminate against them in any way because they smoke at home or, when they're on their break or whatever, as long as it's, not on our property. So anything that people can do lawfully outside of work, you can't use that as a basis to take a job action, essentially. And so the labor law was specifically amended with the passage of the Marijuana Act to include cannabis as a reason why we can't discriminate against somebody for their lawful use outside of work. So, if you're allowed to use it, whether or not you agree, disagree with individuals being able to use marijuana or to smoke or inhale or whatever, it is whatever your personal views are, we can't use that as a reason to make an employment decision. So So no discrimination based on the legal use of consumable products, including cannabis, in accordance with the state law. And that extends to use that is all of the following. So it has to be outside of work hours. It has to be off of the employer's premises. And it has to be without the use of the employer's equipment or other property. So I suppose I was trying to think of some examples. If I'm an employer and I have a company car and, you know, my employee uses that car, they go home and then they smoke marijuana in the car, well, then it doesn't meet all the criteria of these three these three things. And so it's in the use of my equipment or property that they're doing this. And so in that case, I could say, I don't want you, smoking marijuana in my car, and I could take an employment action based on that. But otherwise, if all of these three criteria are met, then we cannot discriminate against our employees for lawful use. The law also prohibits, with certain exceptions, disciplinary action and discrimination against employees for their lawful use of cannabis. So again, whether or not you like it, agree with it, whether you're old-fashioned or, ahead of the times, whatever it is, your opinion is not relevant as long as their use is lawful. So we can't use that as a reason to take any employment action. So what does that mean? Employers may not take adverse action against an employee because of their legal use of cannabis before or after their work hours. And I will get into that in a little bit, because impairment at work is a completely different story. Or legal use of cannabis during their legal recreational activities off of our premises and without the use of equipment or property. Employees may not be subjected to disciplinary action solely for conduct that's permitted under the cannabis law. Now, the law includes something that's a little bit unique in that it gives employees a private right of action against an employer if there is discrimination. And not every law does that, but the legislature was trying to make a statement here by saying that not only can you be fined by the state for violating the labor law, not only can you potentially, come into some regulation consequences as a result of, not following the law, but these employees have the right to sue you for money and for damages if you violate the provisions of the law that prohibit discrimination. So again, just another reason for us all to be very careful as far as, what we're doing with employees. And, it's legal, and we have to be, we have to treat it as such. So are we protected as employers? We certainly are. The law makes clear that it is not intended to limit the authority of employers to enact and enforce policies pertaining to cannabis in the workplace. So we absolutely can have work rules and policies that prohibit impairment. And we should, right? We don't want anyone coming into the workplace who's drunk, intoxicated, high, or anything else, right? We want everyone to be safe in the workplace. And not only is it a safety issue with respect to that individual employee, but it's also a safety issue with our other employees. And so we want to make sure that we do have work rules in place that prohibit impairment in the workplace. And so going back to that other slide where employees are able to use it legally before and after work, if they're smoking a joint before they come to work, the likelihood of them not being impaired is almost zero, right? And so even though it's legal for them to drink in the morning before they come into work at 8 o'clock, it's not allowed in the workplace. And, in most instances, we have rules that prohibit that. And so we should have the same here. So we still absolutely can have a zero tolerance policy in a drug-free workplace. That also can mean that we don't have to allow people to trade marijuana plants in the workplace. We don't have to allow people to, give each other gifts of marijuana in the workplace. So we can prohibit it from coming into the workplace altogether, and we should. And that's a number one. If you don't take anything else out of this presentation, you should have a work rule and a work policy that prohibits being intoxicated or inebriated or inhibited in any way due to a substance. And you should also not allow those items to be in the workplace. And you also must have a written policy. So just saying it isn't going to cut it. You have to have a written policy so that if you do something pursuant to that policy and you do get sued or you get brought up in front of some administrative body, you can show that, yes, we did have a policy. The policy was published to all of our employees. They knew about it. Here's the signature when, that they received the policy. And they violated the rule. And for those of us that already have handbooks, we can include this as an amendment. And if we do, we should publish it via email or give everybody a copy. And if you're doing it by email, then that is enough of a receipt to ensure that everyone received it. But if you're not doing it via email, then you should have them sign an acknowledgement that they received the new policy. If you don't have a handbook, don't delay. Everybody should have a handbook at the very minimum, by now. And if you don't, get in touch with us. We can do it for you. We have a whole bunch that are already, prepared that we can modify pursuant to whatever organization you have. So make sure that you're either preparing a new handbook or you're updating it to reflect these new laws and the new requirements. The law makes it clear that, it's not intended to limit our authority as employers to enact and enforce policies pertaining to cannabis in the workplace. And again, going back to safety is the number one issue here. We want to make sure that everybody's safe, especially, and I shouldn't say especially, but particularly those individuals who operate heavy machinery or, who interact with the public in any way. We want to make sure that they're not impaired and not going to be, a danger to themselves or to others. The difficulty with marijuana, as opposed to as opposed to alcohol, for example, is that there's no test yet that tells us if somebody is actively impaired, right? So we have to go by our observations. We have to go by what we see and what we hear. And, that is subjective very often. I might think somebody's impaired and Laura might not think that they are, or, there are lots of different things. Sometimes there are different reasons why people could be acting in a particular way. So, we want to be, as observant as possible. And, another trick of the trade is ask somebody if they're looking like, they're just not acting right. You can ask them, are you under the influence of marijuana? Did you drink, or, whatever it is. And sometimes, many times, employees will admit it. Yeah, well, I did, I did smoke a joint before work and I thought I'd be fine, but I'm not. And then you can certainly discipline based on the fact that they're still impaired at work. So even though it's not foolproof, we can't say, oh yeah, somebody, so-and-so is acting like they're high, I'm going to send them for a drug test, because the drug test isn't going to tell us whether they're currently impaired at that moment. We certainly can ask them. And again, we can take action based on our observations. So even if we're not 100% sure, if we're looking at, their behavior and it's unusual, it doesn't look like, like it normally does, then we can take action based on our observations. And, we have an obligation not only to keep that particular employee safe, but to keep all of our employees safe. So we want to make sure that we comply, because we can, it's a pitfall for all of us, right? We can get in trouble if we do the wrong thing when it comes to marijuana and, not allowing it or, enforcing the wrong rules. Well, we can also get in trouble if we have an unsafe workplace because we let somebody come into work who was impaired. So we have to, sort of weigh all of those things. And safety is the most important thing. So those articulable symptoms that we talked about. So if someone is looking, it seems like they might be impaired, what does that mean? So we've got a little guidance. It should be that it decreases or lessens employee performance of their duties. It interferes with us as employers, our obligation to provide that safe and healthy workplace for our employees as required by OSHA. Or if there's a violation of federal law or a loss of a federal contract or federal funding, where the employer's action would require, or the employee's action rather, would require the employer to commit any act that would result in the loss of funding. So I kind of mumbled a little bit, but I want to clarify that. So a lot of times, I'll hear clients say, well, it's illegal under federal law, so I don't have to allow it. New York specifically said that's not true in their law. They said that as long as there's not a federal contract or federal funding that would be implicated, you have to allow employees to do what they will with marijuana when they're not in the workplace or any of those three things together. So you can't no longer say, well, it's illegal under federal law, so I don't have to, if I find out that Jimmy is, taking edibles at night, I can fire him because, it's a federal crime. And New York specifically said that's not going to fly. Again, except if that funding or a contract is at risk of being lost. So just be careful. There are certainly scenarios where, something might be legal in New York and illegal under the federal law. And, we can use that as a reason to prohibit it, but this is not one of them. The legislature specifically anticipated that this would be a potential response from employers, and they cut us off at the pass. So employers may prohibit marijuana use or possession during work hours. And what is work hours, right? What does that mean? Work hours means all time, including paid or unpaid breaks and meal periods that an employee is suffered or permitted or expected to be engaged in work, and all time that an employee is actually engaged in work. So that means throughout the work day, right? We may have an hour lunch break, but you can't go and, ingest some kind of marijuana during your lunch break and say, oh, well, I was not on the clock because I was on my break. No, because we all know that, if it's going to cause you to be impaired when you're back on the clock, that's not safe for anybody. So the legislature specifically said that if it takes place during those work hours, whether or not it's a break, you can prohibit it. And in all time that an employee is actually engaged in work. So let's say my work hours are typically 9 to 5, but I'm working, at 6:30 one evening. Just because that's not my normal work time doesn't mean that I can then, come to work high or, go get high and then come back to work. No, because I'm actually engaged in work, and so therefore it's prohibited. The law does not excuse an individual from driving while impaired either. So, particularly for those of us who have driving as one of our job duties, or have employees who drive or operate heavy equipment or machinery, we cannot. Number one, we have to prohibit it in the workplace. And number two, if we see it, we have to do something about it. So, we can be on the hook as employers for somebody who's impaired at work and doing driving or things like that. So we want to be extra careful that, again, we're observing and doing the best we can to determine whether or not somebody is impaired in the workplace. And again, I realize it's not as easy as sending somebody, who you smell alcohol in their breath, or you can see that they're slurring their words or things like that. Marijuana doesn't necessarily manifest itself that way. So it's more difficult to sometimes find out or figure out if somebody is using, but, use your best judgment and when making those employment decisions. And ultimately you have to weigh, all of the things that come into play. Is this employee impaired? Are they acting in a way that's unusual? If I send them home or if I discipline them for being impaired, am I going to get in trouble for violating the law? And I think if we have some very specific work rules and policies that allow us to make determinations based on behavior that we observe, we certainly can make those decisions when we see something that doesn't look quite right. So there are limited federal safe harbors. I touched on it a little bit before, so we can take adverse action against an employee who engages in off-duty marijuana use if federal or state law otherwise prohibits it, right? Or if complying with the act would require us as employers to violate federal law or result in the loss of federal funding or contract. So the law does not, I have a typo here, I'm so sorry. But the law does not allow us to discriminate simply because cannabis is illegal under federal law. So we have to use those other considerations. The workplace drug testing. The new cannabis law does not prohibit drug testing of prospective or current employees. So you can still drug test. The problem is, what do we do if a test comes back positive? So we cannot refuse to hire somebody, discharge somebody, or otherwise discriminate against somebody who does test positive unless we have a reasonable belief that they're using in the workplace or that they're impaired at work. So, it may not do us a whole lot of good to do these pre-employment drug tests, or even, if someone gets into an accident, a lot of times we'll have, these drug tests, or, we'll send them to get drug tested anytime that an employee is in an accident. And now we really have to think about, if it does come back positive, how do we know it wasn't last week or last night? How do we know that they were impaired? And the answer is there's just no easy answer for that. And as employers, it puts us in a really tight spot, where we don't know. And someday, hopefully, there will be some tests that will be able to show us if somebody's actively under the influence. But as far as I'm aware right now, that's not something that's commonly available. So we want to just, make sure to keep that in mind. It doesn't mean, again, that we can't send people for a drug test, and certainly to check for other substances. There are lots of other drugs out there that are illegal besides marijuana. And so, certainly it's not prohibited for us to test for all of it, any of it, but we can't take action based on just cannabis unless, again, it's, during the workday or in the workplace. So smoking or vaping in places of employment. So there is a public health law, section 1399, that states basically that smoking or vaping cannabis shall not be permitted, and no person shall smoke or vape in the following indoor areas. And so the public health law actually goes for smoking of tobacco, and now it is amended to include the smoking or vaping of cannabis as well. So if it is prohibited in the work area, tobacco smoke, then you can also prohibit it in the or in cannabis. You can prohibit it as well. And so the following indoor areas are specifically set forth in the public health law. It includes places of employment, bars, food service establishments, enclosed indoor areas open to the public containing a swimming pool. I don't really understand why the distinction of a swimming pool, but that's what it says. Public means of mass transportation, so subways, places where you wait for mass transportation, youth centers and detention centers, and any facility that has anything to do with childcare. So those are specifically exempted. Now, another interesting piece of the legislation that I found anyways when I was delving into it is that public and private colleges can specifically specifically state that they're not allowed to have tobacco or marijuana use. And that's perfectly legal, which is interesting, right? Because it's the government that's giving us these regulations, but yet they can disallow it at SUNY campuses. And that it remains the case unless there's some kind of residential situation where it is open to members of the public, meaning members of the public can actually reside there. So it's not for those guests who come on, but actually if like there's some kind of an apartment complex, for example, where, you know, there's college students, but also people who are just general members of the public. If that's the case, then they can't prohibit the use because it is legal otherwise. But if not, then SUNY campuses can certainly prohibit it. So, and then hospitals and other healthcare facilities. There is also zoos and indoor arenas. So, you know, think of like big concert forums, things like that. If, you know, with vaping, nowadays it's really difficult to even know if somebody is vaping because you can't smell it. If it's dark, you can't see it. But if you get caught, it is prohibited and you can be probably fined or ticketed for that. So. Medical use of cannabis is a different topic. So all of what we just said aside, the medical use of cannabis is its own special category. It's governed by the Americans with Disabilities Act. It was legalized in New York in 2014. And if patients are certified to use medical cannabis, they are deemed to have a disability under the executive law and the civil rights law. And so certified patients who are certified cannot be subjected to discipline solely because they are using cannabis for a medical condition. So that's something, again, if we have an employee who does have a medical prescription for marijuana and you have a question about something, just pick up the phone and call us and ask us, and we can walk through it with you and talk through it with you, because every scenario is different, and you know it's going to depend largely on the circumstances. So again, we are, even with the medical use of marijuana, we still can prohibit employees from performing duties while they're impaired by a controlled substance. So again, think operating heavy equipment, machinery, driving, things like that. And we are not required to do anything that would violate federal law or, again, result in the loss of that federal funding. Okay, so what does this all mean for us as employers? And we've talked about a lot of the sort of action items throughout the presentation, but specifically some things that we should do is, number one, review our drug use policy. If we don't have one, let's create one. Let's make sure that we have it in writing and that it includes marijuana and cannabis products in there. But also we want to make sure that, you know, it's understood that, those are legal items, and we're not going to discipline employees for doing what they're entitled to do on their own time legally. So we would either want to remove the reference to cannabis or marijuana altogether, or to specify that, employees, basically what employees do on their own time is their business. But if they're impaired in the workplace, we 100% have a zero tolerance for that. We're also going to want to modify any drug testing procedures that we have, both pre-employment and post-employment. In some categories of employees, like those in the transportation industry, if they're driving buses, if they're driving, public transportation, certainly those in those instances we can prohibit the use altogether of cannabis. But for most workers, a positive marijuana test would only provide us with information that we should not be using when we're making hiring decisions. So we're going to want to, be mindful of that again. And if we do send employees for a pre-employment drug screen, maybe we don't want to screen for marijuana, so that we don't even have to consider that if it does come back positive. And, again, drug testing for marijuana, even during an accident or following an accident, can still be problematic because we don't know how long that's been in somebody's system, and we don't know whether they're impaired at the moment. So we have to really, again, rely on those personal observations to prove these scenarios if we're faced with them. We also want to do training. We want to train our supervisors and train our employees. Employers, we can still discipline our employees for using or possessing marijuana at work. So if you see it, if you see someone vaping, absolutely, you can terminate them, discipline them. It's at your discretion, what we do. And you can also discipline or terminate for individuals who are clearly under the influence, if it's negatively affecting their performance, or if it causes a safety concern. So training is going to be really important for our managers and supervisors, so that they know what to look for and what they can and can't do in a situation where they suspect that somebody is under the influence. And we're also we also want to stay informed. So we're at the very beginning of, what this means for all of us, not only as citizens in New York, but also as employers in New York. And there are going to be a lot of changes. There is a New York State Cannabis Control Board that was supposedly formed when the law was passed. And right now they're fighting over who's going to lead that board. And so they were supposed to issue regulations well before now, and they haven't done it. And the thought was that they would have done it before the legislature closed out their session at the end of the month, and they didn't. So we're in limbo for the next who knows how long, waiting for those regulations to be issued. And so for now, we're kind of all on our own as employers as far as what we can and what we can't do. So we just have to really be aware, stay informed. If you happen to hear something about the New York State Cannabis Control Board, take a second and listen and see what's happening, because hopefully they'll get their act together, and we will get somebody who will be the director of the board, and we'll be able to get some regulations issued. And as time goes by, certainly we will be able to get a better understanding of what we can and can't do with respect to marijuana, and particularly in the workplace. So that is the material that I have for today. We have about 15 minutes left. And if there are any questions, I'm happy to take those now. Hi.
of great information. And I'm just looking over in the chat and Q&A, and I don't see any questions coming through in that feature, but people may be saving those questions for kind of a one-on-one conversation. So at this time, we're going to pop out of presentation mode, and we'll have Jennifer seated over at table 1. So on the left-hand side of the screen, upper left-hand side, you can pop over to the table and have a conversation with her about some of your specific questions. And we have about 14 minutes to address those. Otherwise, please, as Jennifer has mentioned, follow up with them, follow up with her at Underberg and Kessler for some of your more specific questions as well. So Jennifer, thank you again for your time, and we'll pop back over into the lobby area.
Great, thanks.